Okay, hello everyone, and welcome to SLA's second session in their 9 for 9 celebration of Title IX's 50th anniversary. I am Barbara Osborne, a professor at the University of North Carolina and your moderator. Joining me today is a rock star cast of who's who in Title IX. Arthur Bryant, partner at Bailey & Glasser, who was lead counsel for the first Title IX lawsuit filed on behalf of women athletes against their university, and he has not stopped since then. Erin Bezuvis is the Associate Dean of Western New England School of Law and a prolific Title IX researcher, educator, and advocate. And Kenneth Ferguson is a professor at the University of Missouri-Kansas City School of Law, whose research examines achieving gender equity for girls from economically disadvantaged rural and urban and minority communities. So today's seminar is focused very narrowly on Title IX's athletics requirements, the statute, participation opportunities, equal treatment, and scholarships. And we'll try to wind in some of the history and case law, but it's an ambitious schedule for the next 58 minutes. So you're all probably familiar with the 37 words that comprise Title IX of the Education Amendments in 1972. And it very simply prohibits discrimination on the basis of sex at educational institutions that receive federal funding. It's a simple concept that created quite a stir in Congress after it was enacted. Erin, can you shed some light on just how committed to gender equity some of the senators were once they realized that those educational programs and activities included athletics?
Right. I sure will. And I think one of the reasons why realize is an important verb to use is because, I think two reasons. First, Title IX flew under the radar of the law that it was included in.
Okay. So sorry, Erin, I don't know if you can hear us or not. We are having problems with Erin's audio.
I'm terribly sorry. How's that?
There we go. Yes, now we have you. You look so animated.
I'm so sorry. So there was
it's okay, but so the last thing I heard you say was realized was the important part because the statute flew under the radar.
Because it wasn't,
so
I'll abbreviate
there,
my answer.
please.
It wasn't front of mind when Congress passed the law that even Title IX itself was included in the overall statute that it was a part of, because it was such an under the radar, tiny piece of an overall spending bill. And that to the extent Congress did pay attention, they thought they were doing something to eradicate gendered caps and quotas in admissions to law school and other graduate programs. So after the statute gets passed, the ball gets kicked over to the federal agency that would have implementing responsibility, Health, Education, and Welfare, HUE, which is the predecessor to today's Department of Education. And in the course of sort of drafting these regulations, it came to front of mind that there were these questions about how expansive and how detailed these Title IX regulations needed to be. Owing to that kind of confusion or indecision or uncertainty at that point, I should say, stakeholders in college sport, and by that I mean men's sport, because that was the dominant force in town during those days, really pushed hard on a political agenda to scale back the scope of Title IX, using both political and attempted legislative reform, also judicial reform, but I believe that's on Barbara's agenda to address. So part of the effort was to insist that HUE apply, if at all, diluted regulatory requirements to college athletic programs. And then simultaneously, they pushed hard in Congress for amendments that would have exempted athletics altogether. The short of it is that those efforts failed in Congress, and HUE pretty much held up and promulgated meaningful, if not 100% perfect, regulations that would apply Title IX to athletics. I think.
Okay, thank you.
This is next, Barbara.
Yeah, so, all right, and now Now, of course, the screen is not moving. Let's find out what's going on here. Yeah. There we go. Okay, all sorts of fun technology problems today. All right, so yes, as Erin alluded to, the 37 words in the statute really don't provide guidance to the schools as to what they were needed to do. So when Hugh promulgated those implementing regulations, which became effective on July 21st, 1975, they focused on three main areas. All of Title IX does apply to athletics as well, but the athletics specific regulations in Section D really focus on this. The push and pull relative to the regulations, I think Marcia Greenberger actually is going to talk about at SLA's next 9 for 9 session in a couple of weeks. But it's important to note that women's intercollegiate athletics at this time was really operating mostly as club sports. And it wasn't until 1971 when the AIAW was founded as a national governing body for women's intercollegiate athletics that hosted regional and national championships, that women's true varsity athletics programs were started. And while equity and inclusion are stated in the NCAA's current core values, the association was so opposed to equality for women's athletics that they actually filed the first lawsuit, NCAA versus Califano, which was decided in 1978, to have the regulations related to athletics revoked. Their reasoning behind that was that the rules requiring equal treatment and scholarships would conflict with NCAA rules, and therefore they were arbitrary and capricious. The case was dismissed for a lack of standing, as the NCAA itself did not receive federal funding and was not subject to Title IX, but it also failed to prove how its members would be harmed to meet the injury in fact test. And so just 4 years after losing this lawsuit, the NCAA's solution was basically to stage a hostile takeover of the AIAW by offering women's championships in 1982. And that effectively put the AIAW out of business in the next couple of years. Sadly, the NCAA currently still doesn't offer as many different sport championships opportunities as the AIAW did way back in the early 70s and up until the early 80s. So I think most people are aware that Title IX applies to college athletics. Kenneth, can you tell us a little bit about how Title IX applies to K through 12 sports programs?
Well, as you mentioned, the authority to regulate not only collegiate sports, but also interscholastic sports comes right from the statutes and the regulations. And so any institution that receives federal funds is going to be subject to Title IX. And since Title IX is controls or impacts athletic programs as well on the interscholastic level will in fact be impacted, and they will have to follow the requirements and restrictions set forth both by the statute and by the regulations in terms of meeting the needs of women and girls in interscholastic athletics as well. So the whole realm of Title IX is applicable to K through 12, although there's an issue concerning how strictly do you apply it to interscholastic athletics, because the interscholastic athletics are a little different than NC2A. So, but it applies, and the courts have ruled so, and continue to make law with respect to holding interscholastic athletics and schools to the strictures of Title IX.
All right, thank you. So in these, we have the regulations, and schools are now on notice that elementary schools have a year, middle and high schools have 2 years, and colleges and universities have 3 years to comply. But HEW and then OCR in the US Department of Education were just basically getting flooded with inquiries from schools just trying to understand how they were supposed to comply, particularly when they were talking about fully and effectively accommodating the interests and abilities of both sexes. So schools did not have to provide the same sports for both men and women, but they did have to provide equivalent opportunities and levels of competition. And so in 1979, OCR basically rolls out the three-part test, as well as a lot of other clarifications within the policy interpretation, to give schools a better idea of just what they needed to do to comply. Now, the policy interpretation, as I said, laid out this three-part test, and compliance with any one of those parts, as you probably all know, is enough to show compliance. The ironic thing is that the three-part test has become sort of what most people think Title IX is, and that's all that Title IX is, and that's just not the case. So the three areas, proportionality, showing that you've had a history of continuing program expansion, or that the present program is already accommodating the interests and abilities of your student body, is basically the test that's being used. Arthur, now you had a little something to do with that very first case that female athletes filed against their school. And I was working in college athletics then, and I know that every athletic director in the country was on the edge of their seats watching to see what was going to happen in this case. So why don't you tell us a little bit about Cohen versus Brown University, and why that case is so important in Title IX jurisprudence?
Thank you, Barbara. It's a pleasure and an honor to be here. As Barbara mentioned in the start, I was actually the lead trial counsel in the first Title IX case tried in athletics, which was Haffer versus Temple University in Philadelphia.
Right.
And after 3 weeks of trial, Temple agreed to settle and treat men and women equally. And after that, whenever any school canceled a women's team, I would usually get a call. I would tell the school either put them back or we're going to sue. And almost always they would put them back. At most, we would go and get a preliminary injunction, and then they would put them back. But nobody fought beyond that until Brown University. And Brown University basically said, how dare you accuse us of sex discrimination? And it went just like we told them it was going to go. We did a class action on behalf of all the women athletes and potential athletes in the school. And I think the technical legal term is they got their head handed to them. We got a preliminary injunction preserving the two women's teams they were trying to eliminate while the case was proceeding. They went up to the Court of Appeals for the First Circuit. First time anybody had gone to the Court of Appeals on Title IX athletics at all. So there was no case law. We won every single issue. Went back to try the case. On the eve of trial, they settled in terms of treatment and said they would treat women and men equally, but still wanted to argue about participation. So at trial, the judge not only after the trial ordered them to keep the two women's teams they were trying to eliminate, he ordered them to upgrade from club to varsity status several other women's teams to achieve proportionality. We then went up, they took it up to the Court of Appeals, which again ruled in our favor in every way, again making new law, helping women all across the country and clarifying the law. The US Supreme Court denied review. It went back to the district court, and ultimately a consent decree was entered. But 6 years later, we don't have the specific figures, but we were told back then in the 1990s, they were spending over $3 million more a year on women athletes than they had before, just to provide equal treatment. We were told their attorney's fees were $3 million. We know they paid us over $1 million back in 1990s. And Ms. Magazine named, it was such a big stink, Ms. Magazine named the president of Brown University the winner of the Male Chauvinist Pig of the Year award. So after that, not only did every school in the country watching this, because if Brown was in violation, this liberal Ivy League school, then what is most of the power schools going to say? What are most of the football schools going to say? Well, if Brown's in violation, then we're definitely in violation. And that, they got held accountable. Whenever a team got eliminated after that, it was, look, you either want to put them back and get a compliance, or do you want to be like Brown University? It was not a fun choice for anybody, except us and the plaintiffs.
Thank you, Arthur. Erin, so a lot of people think that the only way schools can comply is with the proportionality test. Now, oops, sorry. I'm going to put this slide up here that has a bunch of red flags, because these are the types of things that people make excuses about. And I don't necessarily want you to talk to them. It's just more for the people, but you can if you want. Tell us about the options that schools actually have, and then about how schools try to manipulate or get around those options.
Sure, yeah. So, I mean, as the 1979 policy interpretation says, there are three options, technically speaking, for compliance with Title IX's requirement to provide an equitable number of athletic opportunities. I think I can work in an answer to Kevin's question with this answer that's about to happen. Technically, you can still make a theoretical argument for compliance under prong 2, for example, a history and continuing practice of expanding opportunities for the underrepresented sex. But think about the practical limitations of that argument. If women are the underrepresented sex, and they've been the underrepresented sex since the beginning of this test in 1979, that's an awful long time for you to keep up the momentum of satisfying that standard, a history and continuing practice of expanding opportunities for the underrepresented sex. And so for the most part, for schools that have been in that position from the beginning, you've either added enough opportunities to comply with that standard that you now comply with the proportionality standard, or you don't really comply with prong 2. So there are some practical limitations inherent in prong 2 at this point in history. Prong 3 is interesting. It's looking for evidence of no unmet interest, which really is a burden that the school is supposed to meet, to say, we've looked, we've asked, we've made opportunities available for the underrepresented sex, and they're just not turning out. We're putting the exact same effort into recruiting. We're putting the exact same effort into building the program that we would any other varsity program. And what can we say? Women just aren't interested. That's actually a difficult standard to meet as well for practical terms, because women are interested in playing intercollegiate athletics. If you look at the number, the ratio of high school athletes to college athletes, you can imagine a pyramid diagram. There are millions of kids who play in high school, and only a few 100,000 collegiate athletes of each sex. So where are all those athletes going? It's quite likely that many of them have unmet interest in athletics. The other time your opportunities are limited in terms of compliance is when you're cutting a women's team. And this applies to Kevin's question, even if you're also cutting a men's team. If you are cutting a women's team, you necessarily do not comply with prong 2, because you are not expanding opportunities for the underrepresented sex, you are shrinking them. And you have created unmet interest in the very sport that you just cut, which means if you're cutting a women's team, you have to comply with proportionality. That's one place where you really do back yourself into that corner. And that applies, like I said, even if you're also cutting a men's team. Now, if you cut a men's team at the same time such that the numbers end up in proportionality compliance, well, that's okay, that's compliant. But many examples of schools that have cut both the men's and women's teams together, from a starting point, men had so many more athletic opportunities or many more opportunities relative to their share of the student body population, or both, that it would have taken even more cuts to men's teams to wind up in proportionality compliance. Barbara asked me to mention the Quinnipiac case because this also demonstrates a couple of ways that schools might be tempted to try to make a showing of proportionality. And this case demonstrates that the courts are really looking over school shoulders to say, we're not just going to take your numbers on faith. If you say that 56% of your athletic opportunities are going to women, we're going to actually ask you to demonstrate that those are all individual athletic opportunities that hold up to scrutiny and that match the same level of quality and expansiveness of the opportunity to compete that any other varsity team in your program has, including men's teams. So Quinnipiac came about when the school decided to cut their women's volleyball team. And the women said, oh, this is a Title IX problem because there's no prong 3 compliance anymore, no prong 2 compliance anymore. And look at your numbers, you're out of proportionality. And Quinnipiac tried to argue that they were in proportionality, but they did so with some numbers that the court scrutinized and eventually rejected enough of that Quinnipiac was found not in compliance. So one thing Quinnipiac had done is added a new team in a sport that was not fully developed enough to satisfy the requirement that its opportunities were meaningful athletic opportunities. The sport was competitive cheer, and this is not an indictment on competitive cheer in and of itself. Everyone knows that is an athletic activity, requires a lot of strength and skill, but the way that sport was structured at the time, there were just not as many opportunities to compete, such that Quinnipiac's team was competing against high school teams. Sometimes they were competing against teams where the rules of competition were not consistent or fully fleshed out. They were competing in situations where there really wasn't the same kind of regular season with a postseason progression the way other sports at Quinnipiac worked. So the court said, until this sport actually behaves like another sport in your program, we're not going to count this as a source of athletic opportunities. Similarly, Quinnipiac tried to double count duals or triple sport athletes in situations where each individual sport was not holding its own as a source of athletic opportunities. And specifically what was going on was that the school was really committed to its cross-country program and asked its cross-country runners to participate in track for the other 2 seasons of the year, winter and spring track. Ordinarily, those would count as 3 separate athletic opportunities. But the way Quinnipiac was doing it, those cross-country runners were basically having a glorified off-season, an extension of their cross-country experience as opposed to 3 distinct athletic opportunities. And the court said that shouldn't count as 3 separate opportunities as well. So with the revised numbers, the court confirmed that Quinnipiac had violated Title IX and gave the volleyball team remedies and being reinstated or some other fix on the part of Quinnipiac. The story continues because they tried to then add other teams, including rugby, and that took us into some other legal territory. But what this case, I think, really should stand for lawyers and for those concerned about equity in college and collegiate athletics is that the court's looking over the school shoulder for evidence of numbers that aren't quite right. The numbers that are being proffered as athletic opportunities that really aren't truly genuine athletic opportunities on their own.
Thank you, Erin. Now, Kenneth, equal opportunity has not been equally applied to all women and girls. Can you tell us a little bit about your research and unequal opportunity and the impact of Title IX on girls and women of color?
Well, before I give sort of a brief description of the difference in opportunity gaps between men, women, boys and girls, between girls and boys and girls of color, I want to sort of introduce sorry about that. I wanted to do sort of its intersectionality because it plays a part of my research, and it also plays into some of the research that has been recently done by the Women of Sports Foundation. And so intersectionality theory rejects the assumption that girls, women have identical experiences and therefore should be sort of evaluated for whether or not they've been discriminated against as a group, okay, as opposed to looking at their own individual experiences, whether they are, you know, from a particular social background, their gender, you know, their economic background. All of those factors may play into determining whether or not this particular girl, woman within this group is being discriminated against, rather than whether we evaluate her situation through the whole group, gender or race. And so the National Foundation, the National Women's Law Center did a study called the Finishing Last Girls of Color and School Sports Opportunity. And they sort of took a intersectionality approach to their work. The work revealed that girls of color received far fewer sports opportunities than white girls, white boys, and boys of color. This inequality phenomenon for girls of color has gone largely undocumented due to the limited research that has been done and the focus on the experience of girls of color. So, so rather than taking a sort of a broader group approach, the Law Foundation looked at schools throughout the nation that were either 90% white or 90% students of color. The reason why girls of color are finishing last is because even though minority schools typically have fewer resources and provide fewer spots on teams compared to schools with populations predominantly white, minority schools also allocate those fewer spots unequally, such that girls of color get less than their share of those sports participation opportunities. Girls of color then are referred to as being doubly disadvantaged. According to the report, 40% of heavily minority schools have large opportunity gaps compared to 16% for heavily white schools. So within those schools that are predominantly Black, the opportunity gap, participation gap is 40%. This inequality found not only on a national level, but it was found on a state level as well, because when the study looked at states' schools, they noticed that there were about 13 states that exhibited the same phenomenon, in that there's a wide opportunity gap between boys of color and girls of color, and as compared to boys of white or Caucasian boys and Caucasian women. Now, this phenomenon, in terms of looking at these schools, was also recently reflected in some larger Title IX problems that Philadelphia, for example, had. And I won't go into a whole lot of that, but the study was also reflected, at least the results of this study was reflected in what was going on, not only in the athletic departments of schools in Philadelphia, but it was going on with respect to funding, and those funding deficiency also exacerbated the opportunities, sports participation opportunities that would be available to girls of color. So you've got this situation where the same disparity that may be reflected in majority population schools is exacerbated in minority schools because of the lack of resources and the same effort to benefit boys of color versus girls of color. So hence, that's why the study indicates that girls are finishing, or girls of color are finishing last.
Thank you, Kenneth. Yeah, that's really depressing news to hear, particularly since it was Black college-educated women that were our first college-educated female Olympians in the U.S.
Absolutely.
So we definitely have a long way to go to rectify these issues.
Barbara,
Yes,
can I just jump in before we leave?
absolutely. Go for it.
I just
Arthur.
want to say before we leave this slide, because if anybody came in late, these are all red flags. The point is, this has been up on the screen a long time. They are not legal justifications for depriving equal opportunities to women. Any school who advances this is in trouble if they have to advance this because they're likely in violation. That's it.
Right. The red flag should have been the cue, but absolutely. And I did say how schools were trying to manipulate. So
Right.
yes, if you didn't come in late and you missed those things, thank you very much, Arthur. Sure. Well put. So moving on to now our next slide, if it'll let me do that. Okay. I did mention before that a lot of people think that the three-part test is it for Title IX, but the Title IX regulations include a long list of categories that require equal treatment. And these categories are on the slide. These categories are to be assessed as to quality and quantity. And it's not a sport by sport comparison. You are looking at category by category at the women's program as a whole compared to the men's program as a whole to identify the differences and then examine those differences to determine whether that difference amounts to discrimination that basically prevents the underrepresented sex or the discriminated against sex from getting the full benefit of their athletic opportunity. So research reports that very few, if maybe any, schools are actually fully in compliance when you look at the requirements under this list. Big disparities, especially relative to facilities, travel, promotion or publicity, and recruiting. So I'm going to actually throw back to you, Kenneth, because of your former involvement in the NCAA certification process. Can you tell us why colleges and universities are just not in compliance?
Well, you know, since the certification process obviously was terminated, the monitoring is done internally. And so in some instances there's, and I think Erin might have mentioned this too, that there's incentive to sort of fudge or overrepresent the participation opportunities that are being provided to women by double counting and so forth. And so you've got a lot of those issues as well. And I think one of the issues that you have on a collegiate level is the attempt to create gender equity through emerging sports. Okay. And with football and so forth, there's just no way to match that. And so hence the motivation, so to speak, to double count or to increase what appears to be increased participation opportunities for women.
Okay, thank you. Erin, do you have any insights? Well, based on the things you've read, the things you've studied relative to schools not being in compliance or not even paying attention really to this list of categories?
Well, one point that I'll add, that I've observed a lot of equal treatment problems stem from the distorted impact of booster club donations. So I think it's commonly maybe misperceived that, well, if you're getting a gift from an outside source and, they just happen to favor men's sports, it's not our fault. We didn't ask them to give us this money that is now creating an inequity because we're using that money to upgrade the men's facility or to give the men's team some kind of special treatment. But OCR has been very clear, and courts as well, all along, that if the school is running the athletic program and the school is accepting the gift, the school's obligation is to mitigate any inequity that might result from the gift, or figure out a way to get that gift to be more even-handed. I think that is increasingly becoming more well understood, but for a long time, I think it operated either as a genuine source of confusion or an excuse for schools to perpetuate inequalities.
Thank you, Erin. Arthur, we saw a lot of these inequalities exposed last March when female basketball players revealed the inequities between the men's and the women's NCAA basketball tournament. Now, is the NCAA required to provide equal opportunities in their championships?
Well, the NCAA takes the position that legally it is not. There was a Supreme Court case, NCAA versus Smith, in 1999, that it was advanced by the plaintiff that the NCAA was covered by Title IX simply because the schools were covered by Title IX and paid dues to the NCAA. And the Supreme Court, in a unanimous decision written by Justice Ruth Bader Ginsburg, said that alone didn't mean that they were covered by Title IX. But surprise, surprise, the decision also was very clear. There are other theories under which it could arguably be covered by Title IX. The first was that the NCAA got funding from the federal government through the National Youth Sports Foundation. I had been involved in a lawsuit against the NCAA. We won that ruling. And then the NCAA, since the 1990s, really hasn't taken any federal funding. It's protecting itself that way. But the other theory is that the schools have given over responsibility to the Title IX for basically overseeing given over to schools to the NCAA to oversee their compliance with athletics. And if the schools have given over to the NCAA authority over their athletics program, which they have, then it would be covered by Title IX. We are waiting for and eager to have the first or second or however many test cases we need. I have no doubt the NCAA is going to be covered by Title IX. And I think the NCAA knows that. That is why its response was not just a PR response. It hired a law firm to do an intensive investigation of what it could do to get into compliance with Title IX. And surprise, not to me at all, but the NCAA hired to do that the law firm that had represented Brown University and Dartmouth when we recently sued them for violating Title IX. And so this was a firm that represented schools that were violating Title IX and agreed to stop doing so. But the reports they've issued, there are 2 so far, are very good and go into great detail about how the NCAA is treating women way worse than it's treating men, and all the changes it needs to make. If you want a template for all the ways in which the NCAA is likely violating Title IX, you have it there. But I want to just raise the larger point for a second. I don't want to get lost around the NCAA. The truth is, almost every school in this country is violating Title IX, because even if it's offering equal opportunities and if it's offering athletic financial aid, it is not offering equal treatment to women and men. The legal principles, the analysis is very simple. You can think, oh, there's all these details and oh, there's a 3-part test. It's really very simple. There are separate programs for men and women. And under the law, those separate programs have to provide equal opportunities, equal treatment, and equal financial aid to men and women. It is literally, in this one area of the law, separate but equal is the principle. It is not difficult to understand. And the NCAA's, when Sedona Price put up those videos, it was sort of a striking example of just what the reality is in this country, at most schools even, of the difference between the treatment being given to women and men.
Well, that's a perfect segue, Arthur, to our next slide. And I'm going to ask Erin just to explain the scholarships requirement.
All right, so the regulatory requirement for equity in the distribution of athletic financial aid or scholarships is a dollars test that is measured by proportionality. So what you do is you figure out, of your student athlete population, what percentage of them are male and what percentage of them are female. And then you compare that to your budget for athletic financial aid, and you ask what percentage of that budget goes to female athletes and what percentage of that budget goes to male athletes. So it's proportionality relative to the actual number of human bodies that you have participating in your athletic program. The reason why that's important and why I'm emphasizing that proportionality is because that's different from Title IX's requirements for proportionality in the distribution of athletic opportunities, which asks you to match it to the percentage of undergraduate students or students in your population of each sex. So what happens is schools are failing compliance with the proportionality requirement of Title IX as applied to athletic opportunities. But then they have, so that reduces the percentage of the athletic financial aid that they have to legally give to female students. In fact, there are way more schools that are out of compliance with the athletic financial aid requirement, not because they are providing too little money to female athletes, but because they're providing too little money to male athletes under that standard. When you zoom out though, if you took a hypothetical snapshot of the athletic opportunities that schools would have to offer to students of each sex to comply with the athletic opportunity proportionality prong, you can see that their failure to do so is constraining women's athletic financial aid by hundreds of millions of dollars. So it's kind of a complicated analysis. You can't say that schools aren't complying with the athletic financial aid requirement to women's detriment, because they kind of are, at least outside of the most elite competitive subdivisions of Division I. They are complying with the scholarship requirement or not complying to women's benefit, but that's not enough to overcome the hypothetical additional money women would be receiving if schools complied in the first place with equitable athletic opportunities. I hope that's clear.
That's great. Actually, really, really well. We've got a couple of questions here in the chat. And so Morgan Chall had asked everyone, isn't it true about the men's, you look at the men's program as a whole versus the women's program as a whole, but does that comparison itself impact the ability of Title IX to ensure equal treatment for women's college athletes? And if so, how would you change that? So I think this question is kind of maybe referring back to sort of the thing we saw with the NCAA, right? That they had their women's championships in a silo and the men's, and neither side really knew what they were doing. So that allowed all of those inequities to perpetuate. But it's a little bit different for the schools and what they're examining. So who would like to tackle this one?
Let me address that a second. Yes, in theory, it's the comparison is program to program. So in theory, a school could theoretically provide better uniforms and equipment and supplies to men, and better scheduling and recruiting and coaching and facilities to women. And in theory, that could all wash out. It just doesn't happen in the real world. Similarly, in theory, a school could treat the football players and the basketball players on the men's side like gods, and the rest of the men like crap. And the rest of the women, all the women sort of in between, and in theory, it could all wash out and it could be theoretically equal. But in the practical truth of the way college athletics is these days, that doesn't happen either. What's actually happening is in almost every school, the men in the football and basketball teams, over 100 men, are being treated really well. Maybe the women's basketball players, 15 or so, are being treated almost as well. But otherwise, everybody, the women are getting treated often worse than the rest of the men. So look at the program as a whole, the comparison is quite simple. The men as a whole are being treated better than the women as a whole. And even when you do side-by-side comparisons, there's an article today in Sportico magazine that says, Sportico on the web, college sports, college hoops spending gap prevails as women trail in two areas you think would be equal: travel and spending on meals when you're traveling. And the schools are specifically identified by name with dollar amounts, paying way more for the equal sized men's basketball team to have meals when they travel than women's when they travel. And they interview the AD who says, well, I don't know, maybe it's that men eat more than women, or maybe that we give them more food than women. And you're just thinking, this is the best thing you do. They got a problem.
Well, thank you, Arthur.
Sure.
Did anybody else have anything to add here? There's another great question in the chat. It says, if the panelists could include one section in a federal name, image, and likeness bill to protect against gender equity, what would you include and why?
To protect against gender equity or
Against inequity.
Inequity. I'm sorry, reading it wrong.
Yes.
Yeah, to protect against gender inequity. So basically, if you're crafting a section in an NIL bill to protect gender equity, what would you include and why?
Well, so let me just address this for a second. I wrote an article in Sportico just 2 weeks ago, because Title IX actually does apply to many of the NIL situations. If there is a private company and it's totally private and it's giving the men a better deal than the women, it's not covered by Title IX because the private company is receiving no federal funding. But if the school is involved at all, and almost always it is because it involves the school's trademark on the uniforms than the ad, or God knows what else, could be school facilitated things, it has to give equal treatment to men and women, and it has to make sure it's complying with Title IX. So if there were to be a federal bill, I think what you wanted to say is that men and women have to get equal opportunities and treatment when it comes to name, image, and likeness by whoever is providing the funding.
I agree with you with respect to what the federal law should say, because as some of the state laws are written now, you could sort of outsource the name, image, and likeness, with the idea that, well, Title IX doesn't apply to that. But if that were the case, then you could outsource to third parties your responsibilities on the Title IX, and you'd be okay. So I think the schools, regardless, will be subject to Title IX because they've got an agent, whether formal and informal, that's making these decisions about name, image, and likeness. And so there could still be some Title IX problems for a school that doesn't have some kind of control over how those deals are made, or at least be able to have a sort of a institutional eye towards compliance, so to speak.
Well, Kenneth, I agree with you. And anybody who's on this show or watching this show that's actually advising schools, they need to make sure the schools are aware of this. I mean, there's a huge Title IX liability risk. I should also say anybody who's a woman who's being given unequal opportunities, call me, because this is a clear area of exposure for the schools, and I want to make sure that people are treated equally.
So there was a question in the questions that asked whether Title IX protects trans students who want to play sports. And I want to tell you that Title IX absolutely does, but there will be another session devoted solely to that topic in this 9 for 9 series. So we were asked not to address those issues today. So definitely check in for that next series. We are in our last 6 minutes. So I'd like to pose this last question to all of our panelists. What will it take to achieve equity in school-based sport programs, or what can people as our crowd as attorneys, what can attorneys do to facilitate change? So Ken, do you want to start us off, or?
Well, I could start off more from a philosophical standpoint and say, look, people they've got to honestly decide they want to achieve gender equity. I mean, if you don't start there, I think, then the potential for not reaching your goal is pretty high. And so there's now, and the problem with even making that statement is, laws can't legislate morality or conscience, and so you've got to have the standards, you've got to have rules that keep people within those boxes. But even under those circumstances, if you've got people that really don't see the value of equal opportunity for women, then this problem continues, and they become more efficient, effective of avoiding those obligations. So, I mean, that's the only thing that I could say in response to your question.
Okay, Erin?
Well, I'd like to answer that question from the standpoint of kind of what could anyone do, regardless of whether you're an attorney or not. And whether you're, and this might apply to people who are attorneys, but maybe not in a position to be, representing plaintiffs or institutions in Title IX matters. But all of us went to school somewhere. Many of us have children or other family members who've gone to school, or maybe we live in a college town and we've built up allegiance and loyalty to a particular team. So that's what's creating this impetus for commercialized college sport. My criticism of that on its own could be for another time, but given that we have this commercialized model of college sport, why aren't we using our power as consumers and as fans to influence compliance decisions? I can understand that some of this stuff is subtle and difficult to understand. And it might be hard to rally fans around, the argument I made about hypothetical compliance with the scholarship regulations and blah, blah, blah. But on the other hand, there are schools that are notorious for rampant sex discrimination in their athletic programs, high profile sexual misconduct, suppressing evidence that members of an institution's medical staff, for example, was abusing female athletes. That university somehow still has fans. For some reason, there are still people willing to shell out big bucks in donations and season ticket prices to go watch sports like that. And so I think there's a real disconnect among us, the consumers, the fans, the members of the general public, however we describe ourselves, that we're somehow not responsible or that this isn't our problem. But if we're putting our allegiance and our loyalty behind institutions that are perpetuating harmful sex discrimination, that's on us, and we need to cut that out.
Thank you. Arthur, I'm going to let you have the last word.
Oh my, well,
except for the thank yous, I'll take the last word.
Well, then I'll start by just saying thank you to everybody, including you, Barbara, for including me. I just want to say, I think fundamentally you need two things. One is commitment, which is what Kenneth talked about. And the other is enforcement. And right now, part of the problem is that in 50 years, almost 50 years, the federal government has never brought an enforcement action against any school in court to make them an example. And I believe if the federal government did that with one big school, one of the top football or basketball teams, and made an example of them, everybody else would get in line quickly, because it's all of a sudden the cops are on the beat. Right now, the cops in this country are women athletes and private law firms like me and the National Women's Law Center and groups doing that. And I'm happy to do it. It's the right thing to do, but that's not going to square every school in the country. We've done one school a month for the last almost year. They quickly fold and agree to get into compliance because they're in blatant violation. But and every woman in the school needs to know they've got rights. In terms of the attorneys and non-attorneys, to the extent there are leaders watching this, the leaders need to lead. That is, you go in and you say, this is the law. Discriminating against women or men is wrong. We need to stop it now. What are we going to do to get our school to do it? If you're not on leadership, then I think sort of three things. One is you educate, get educated and educate others. Two is you agitate, however you can. And three is you litigate. Because the only thing that's really made the difference up to now in almost 50 years is litigation. And that's where I and all the sports lawyers watching this program can do it. If anybody wants help in how to do it, call me. But it's time. It's almost 50 years. Enough is enough.
Thank you. I couldn't agree actually with all of you more. And I know we're over by 1 minute, but I'm going to add my 2 cents anyway. As far as the enforcement action aspect, it was 15 years ago that I made an appointment at the U.S. Department of Education and sat down with them and wanted to talk to them about creating a national standard for an education program. And the impetus for that was to lobby the NCAA to establish a rule. Right now, the NCAA has rules that require anyone involved in recruiting to have to pass a recruiting test. So why can't we have an OCR approved test, Title IX education test, and if you get hired to work in a school-based athletics program, you have to take that test and pass it in order to have your job. Just one possible thing to think about, right? Anyway, thank you so much to our panelists, Arthur Blank, Erin Bezuvis, and Kenneth Ferguson. Also to Jema Meyer and her Title IX Organizing Committee and SLA for sponsoring this 9 for 9 series of seminars. I hope that you'll join for the additional 7 to come. And thank you all for joining us today. We really appreciate it.
Thank you.
Thank you.